Let me start by saying here, as properly noted by the appellate division, plaintiff's claim is based on Coach Philmeyer's failure to properly supervise and oversee the participants of the sport she was tasked to instruct. Participation is something far different from instructing, from supervising, from coaching. This is not a traditional Crawn case. This is a negligent supervision case, as properly noted by the appellate division. And through the course of the litigation and obviously preparing for the appellate division in this argument today, I've had the occasion to read Crawn versus Campo several times and really gain an understanding of what Justice Handler was talking about when he decided to set the duty of care between equally situated co-participants to this duty to refrain from engaging in injurious conduct that's the product of recklessness or intentional behavior, all right? And he starts by looking at the relationship between sports participants, and he notes that it's derived from a consensual relationship that involves both articulated and unarticulated rules, obvious and obscure conventions, and clear and not so clear expectations. Now, when players step on the field, in many sport scenarios, there's an expectation that physical contact may occur. Even in sports that are traditionally characterized as non-contact sports, such as golf, as this court noted in Schick versus Ferolito, there is a certain level of risk that's being assumed by the participant. But the degree of what physical contact is being consented to in this consensual relationship among participants and the nature of the risks that are being assumed by the participants varies. It's highly subjective. What my understanding of hard play may be someone on the other side of the field be considering a flagrant foul. So Justice Handler recognized that this is a highly subjective relationship in terms of what's being consented to when stepping onto the field. So in the context of this consensual relationship, he said, we're going to set the standard at recklessness or intentional conduct. That's what participants have the duty to avoid in terms of causing injury. Because clearly, when stepping on the field, no one's consenting to that type of excessively harmful conduct. But this consensual arrangement between equally situated co-participants was never intended to apply to coaches or anyone tangentially involved in the recreational sports context, okay? There's no published opinion that applies the Crawn standard to a coach. Every case that applies Crawn following the 1994 decision applies it in the context of the plaintiff getting hurt by another participant, either who collided into the plaintiff or somehow otherwise caused the plaintiff to suffer some sort of injury. You have Schick versus Ferolito, where the member of the foursome takes an unannounced second tee shot, a mulligan, if you will, and strikes the plaintiff in the eye when the defendant admittedly realized that the plaintiff was in the line of fire. You have Anglin versus Mountain Creek Resort, in which a snowboarder causes a skier to fall and ultimately strike his head in the concrete barrier and die. That applies the Crawn heightened analysis to the conduct of the snowboarder. You have Obert versus Barada, in which the plaintiff and the defendant collide when they're both going for a fly ball during an informal intra-office softball event, which I'll note, there is no coach involved in that, okay? You have Judge Sabatino's decision in CJR versus GA, in which the conduct of an 11-year-old lacrosse player who strikes the forearm of a player on the opposing team is evaluated under the Crawn heightened standard. I recognize that there's a little twist to that case because Judge Sabatino gives us this two-layered analysis in terms of analyzing the conduct as if it was committed by an adult under Crawn's heightened reckless standard, but then looking at whether or not someone at 11 years old is still held liable, given their age, intellect, and intelligence. Age, intelligence, and experience.
We weren't dealing there with whether the coach would be liable.
Right. It was
opposing player or the
opposing player,
parents.
and that's really what I'm trying to drive home. Is there's no decision that applies Crawn outside the context of participants engaged in the actual activity itself. All right. So this is not a Crawn case. This is a negligent supervision case in which Morgan Dennehy was brought out to the D zone, instructed by Des Philmeyer to begin practice during a time slot which was prohibited pursuant to a calendar created by the athletic director, Coach Philmeyer's boss, which was completely violated.
So putting aside whatever the degree of negligence you have to show, what exactly is the act or omission Philmeyer committed that you're complaining of?
It's instructing the field hockey team, including Morgan Dennehy, to be in the D zone and begin practicing on the turf field facility prior to when they were scheduled to do so. Their practice was not to commence until 3:45. In the meantime, from 2:30 to 3:45, the boys' soccer team had priority or were permitted to use the turf field facility. So by bringing her to the turf field in violation of the calendar, it exposed her to the soccer ball, increased the risks that would otherwise be associated with Morgan playing field hockey. I said this when I appeared before the appellate division, but when Morgan Dennehy signed up to play field hockey at the Hightstown High School, she did not sign up to get struck in the head by a soccer ball from an ongoing boys soccer practice.
What about Rosania? You said there was nothing involving an instructor. Am I pronouncing that correctly?
Rosania versus Carmona was the case in which the
karate
instructor didn't convey to the plaintiff that there was, well, let me step back. Pursuant to the plaintiff, there was dojo rules that prohibited strikes, I believe, above the head.
Right.
And when
it was in the eye.
Right. When the plaintiff was going for the black belt proficiency exam, the instructor struck the plaintiff in the eye in violation of the dojo rules. Right. So
you have an instructor-student relationship.
Right.
There.
But in that case, the instructor's actively engaged in the recreational sport context. In that case, karate. Okay. Coach Philmeyer is not actively participating in field hockey practice, regardless of how loose you want to define.
Well, she didn't
coaching.
kick the soccer ball, but if coaches, field hockey or otherwise, are running back and forth. They're physically active during a practice. Where does the line draw?
Well, I think normal expectations for minor players and adult coaches is that the adult coach is not going to enhance the risks that are otherwise associated or inherent in the sporting activity itself.
But we're not talking about enhancement of a risk. We're talking about what standard of care applies. And so the enhancement of the risk is something to be debated pursuant to whatever standard of care applies.
Right.
But coaches, the batting practice example was used. There are a lot of situations where coaches are kicking a soccer ball around with their players or taking a shot on goal to give the goalie some practice and so forth. To say a coaches, at least in my limited experience, are not generally standing stationary and just bossing people around. They're involved.
Right. So I think the main distinction between a coach in that context who's providing instruction and as appellants characterize in and about the players on the field is the level of emotional intensity that's present. There really is none in the context of instructing the players versus two equally situated participants where the objective is to win the game.
So the standard of care relies on the level of emotional intensity?
No,
if you had the instructor in the karate case, Rosania is an expert, presumably knows the rules, and is engaged in essentially a test of the student's skills to see if the student qualified for the whatever the belt was. Okay, so the instructor is acting as a coach as he is engaged in the karate. Why is that so different from this case?
Well, you're dealing with two adults, and you're dealing with the instructor defendant who's engaged, causing physical contact to the plaintiff in that case in violation of the dojo rules.
I don't see the adult thing factoring in here. You've got the ski accident involved a child, if I remember correctly. The baseball case that Judge Sabatino decided involved a child. So yeah, there are probably a lot of different relationships that could happen here. But where's the line that can be drawn that distinguishes the Crawn situation from a coaching situation?
I think it comes back to exposing the participant to physical contact. All right, and you don't have that with instruction.
So take my hypothetical with your adversary. Instead of the defendant in Crawn being the player, let's say the coach wanted to get in the game, and the coach was on second base and takes out the catcher plaintiff.
Right. In that situation, I think you have to look at were the risks otherwise inherent in the sporting activity itself, in this case softball, increased by the coach. Now, that would be up for debate in terms of whether or not the coach was advised by the players, I guess in your hypothetical, to not slide or to not participate overzealously in the game.
No, my question goes to what Justice Patterson was questioning you about. Where do you draw the line? Is it really a title that we should be caring about, coach, instructor, or is it what does participant mean? And if you have a coach or an instructor participating in the sport itself and trying to promote the rigorous participation in the activity and injures the other participant, then wouldn't the heightened standard apply in that circumstance?
If the coach themselves is actually participating, exposing the players to physical contact, I would tend to agree with that.
And I know we talked a little bit about how the instructor in the karate case was different because the court applied the standard pertaining to an invitee, a business invitee. But as Justice Patterson pointed out, that instructor was sparring with the injured party. And whether that instructor broke a rule in the dojo or not was engaged in the rigorous participation of sparring. So hypothetically, would the Crawn heightened standard apply to that circumstance as well?
To the instructor in Rosania, who's exposing the plaintiff to direct physical contact, yes, I would say so.
But that's the outcome, the contact. I think what the judge is trying to get to is it the fact that this person, he may be a coach, he may be a player, is participating. He's kicking the ball, he's hitting the ball, he's tagging the player, he's swinging the stick. That is what separates the standards. It's not the identity, it's the activity, the actual participating in the karate, sparring, in the running the bases. That's what separates the standard. Is it the participation, or is it standing in the dugout saying, go team, or whatever it is? Take that field instead of that field.
Justice Solomon, I would say it is the participation itself. I would say that, not necessarily the title, but when an adult coach is, I guess, simulating a game situation with minor players, I think the expectation is that
That's different. Now was he negligent? Wasn't he negligent?
Right.
Was he reckless? Wasn't he reckless? Depending on what standard he carried. But that's not what defines the standard. The standard is what's he doing.
Right. I would agree that it is the active participation in the sports context.
So take a case where at the end of practice, the coach says, do some wind sprints, student collapses, and a lawsuit is filed. What's the appropriate standard there?
Well, I don't think in that hypothetical that the coach is participating in the wind sprints exercise. So I don't think Crawn would apply. But then, this concern about opening the floodgates to litigation is you'd have to ask yourself, negligence doesn't equate to automatic liability, and it pains me as a plaintiff's attorney to say that, but you still have to establish there's a breach in the duty of care. And in your hypothetical, Chief Justice Rabner, I don't know if there would be one, short of there being an indication that the player was suffering from some sort of cardiac issue prior to being instructed to do wind sprints. But without a coach actively participating in the sports context, exposing a player to the physical contact that was inherent in sporting activities, as discussed by Justice Handler and Crawn, I would not say Crawn would apply in that hypothetical.
I want to ask you by comparison on the public policy aspects of this. The defense have asserted that if we affirm the appellate division opinion, we're going to discourage people from wanting to serve as coaches. And as you know, in Title IIA for volunteer coaches, ordinary negligence is immunized, right? Why shouldn't we, as a sensible common law rule, similarly have immunity for ordinary negligence for coaches who work for public educational institutions? Because if we don't, as the appellants argued, the coaches are going to be spending more time in depositions than they will be out in the field, and they don't get, I think, paid an enormous amount of extra money to do this. Do we worry at all about discouraging people from undertaking these roles as coaches at schools?
Well, Judge Sabatino, first, Crawn's never applied to coaches, so nothing's changing. With regards to the legislation that Your Honor referred to,
that's a Crawn standard. That's a recklessness standard. You have to. Ordinary negligence is not actionable, right?
Right. That's correct. But subsection F specifically says that it precludes coaches involved in private or
right.
sports.
So it doesn't literally apply, but by comparison, should we have a similar rule for high school coaches and such because of the public policy aspects of it that I've just mentioned?
No, because as the appellate division noted, especially in the public employee context, they already have the defenses and immunities that are afforded under Title 59, including discretionary activity immunity under 59:3-2. So I do not. I mean, the legislature's already addressed this too, like I said, in subsection F of the legislation that Your Honor.
So if the athletic director approaches the science teacher, say, "Would you like to coach after school? We'll give you a little extra money." Oh, no, I don't want to get sued. Is that a possible conversation that we're encouraging?
I mean, if it doesn't outweigh the well-established duty of school personnel to provide reasonable supervisory care to students entrusted to them. Okay, so any chilling effect that would have on coaches, which I submit it wouldn't because nothing's really changing, it's status quo, does not outweigh that policy consideration.
You told us, I think, that your case is about the timing of the beginning of activities. Is that all? That's what, because your allegations are more general, but what the bottom line here is that it was whether or not you consider at the beginning of the practice, allowing the students to start taking shots on goal before 3:45. That's the case.
To be in that area.
To be in the area.
In violation of a calendar that was created by the athletic director.
But wasn't it, correct me if I'm wrong, the calendar allowed the boys soccer team to be on the turf field at a certain time, and at 3:45, the girls field hockey team would then be allowed to be on the turf field. Prior to 3:45, the field hockey team was in the D zone. That's not the same as the turf field. Isn't the D zone the area between the turf field and other fields where the ball stopper netting was installed to prevent ball interference?
That's correct, but the calendar related to usage of the turf field facility as a whole unit, not simply the playing field.
Are you saying there was some sort of implicit rule that no student should be out there prior to the moment practice began?
Correct.
That shouldn't be in the vicinity?
They should not be they should not cross the fenced-in area to access the turf field facility.
Was that a rule?
That was pursuant to the calendar created by the athletic director.
Well, the athletic, I'm sorry, go ahead.
Right, the calendar designated a certain time slot for use of the turf field. So, I mean, what my discussion with defense counsel earlier, the ball stopper netting was installed, it seems, to allow for simultaneous athletic sports activity to take place at varying times. But it sounds like you're saying at all times there was only one sporting activity was allowed in this entire facility, even though it seems as though the purpose behind the construction of this facility was to allow for multiple sporting activities to take place at the same time.
Well, not at the same time, but to use the facility to play various types of activities, but not
So
all
what
at the
was the
same
purpose
time.
of the the netting?
Pursuant to the manufacturer, the ball stopper netting is just that. It's to stop the ball so that the pace of the game is not affected by the ball going out of bounds and someone have to chase after it and then, in the soccer context, throw it in.
Is that why the school district installed the ball net stopper?
For that purpose, I'm not exactly sure, Your Honor.
But don't we get that's all that stuff about the ball net and that's the negligence issue of what is your theory of negligence and what's the jury got to find that. Does that have anything to do with what we're talking about here, the standard of care for the co-participant coach? Does whether or not that's negligence and how to apply that standard, does that have anything to do with the question that's in front of us?
No, not at all.
It goes more to the weight of the evidence as to the negligence standard
For a jury
on the supervisor.
correct, for a jury to find whether there was an actual breach.
But it's important I think, because you've identified your cause of action, okay? And in all of these cases, when there's a standard of care is being talked about, what is happening at the moment when this happens, right? What are the skiers or the snowboarder and the skiers are both engaging in recreational activity, they collide. Baseball collision, they're playing. The moment that this happened, what you are saying is that the field hockey team was in a place authorized or directed by the coach before the beginning of practice that put them in a dangerous situation.
That's correct.
And it has nothing to do, so what we've read about a goalie taking a shot on goal, normally not her position, that's a fact, but it's not the essence of this. This is about where they were at a given moment, and you're saying that was against the contrary to the schedule. So the role of the coach at that moment is overseeing the students and directing them to be in a particular place.
That's correct.
Had practice begun?
No. Oh, well, the girls' field hockey practice had not started.
I understand the time was supposed to be 3:45. Was this a practice going on when this injury occurred?
This was according to Coach Philmeyer, this was instruction to set up in an area to engage in a corners drill to maximize the turf surface because they had a game on the turf field the following night, and the ball travels different on grass than it does on the turf.
So was it part of the practice, even if it started early?
Not the formal scheduled practice. This was more of a drill that Coach Philmeyer requested the players participate in.
Any other